But the Parker decision of 2000 didn't have anything to do with the MMAR. It forced the MMAR into existence. The Hitzig decision forced Health Canada to improve upon it. And so, unfortunately, Health Canada didn't do everything the Hitzig decision had told it to. And in fact, turned around and essentially rewrote a section of the MMAR that had been struck down around the limitations of the number of patients that an individual could grow for, being the 1-to-1 ratio, as it's called. And that is that Health Canada now grants a designated grower permission to have a plant set up for a certain individual. That's it. You're not allowed to grow for more than one person. The most that can happen is 3 individuals can have their grow up in the same address. But they, again, all have to be individually licensed. They can just use the same facility and share a few resources in theory. It's a completely impractical system for a whole bunch of reasons that eliminates the possibilities of specialists in the field that can grow high quality cannabis, and essentially is forcing sick and financially impaired people to put a whole bunch of resources into growing their own medicine. And it's certainly not the case with anything else that is prescribed or given as a medicine. So there's a host of problems with that part of the program as well. I guess time is moving, so I'll switch to some of the other arguments that were also used in the court. It was argued that the access to the program was very difficult, and it was prescribed by the defense that naturopaths should be and could be able to let people into the program. That was considered to be a remedy to improve the MMAR enough to make it constitutionally viable. That was not agreed by the judge. I guess I'll get to the decision in a minute. The access argument was big for the defense. Sorry, I should finish on the 1-to-1 ratio and the 3 growers in one spot thing, because Hitzig again ruled that unconstitutional. Health Canada has basically kept doing it anyway. There is a recent decision as well, known as the Splekopolis or the Carousel decision, where last year in Ontario, a court ruled that those sections were unconstitutional, those 2 parts of the MMAR. So there's been a few court decisions that have struck down those particular sections. And yeah, there's the access argument. That was a big part of the defense as well. I think that's, in summary, most of the arguments. Although again, it was a very long and extensive trial, so I don't have time to cover everything that happened. I guess I'll talk a little bit about the testimony before I get to the decision. And I don't mean to be critical of the trial when I talk about what happened and such. Although for me, the fact that there is a conviction here is not the gold standard, I guess you could say, we were looking for, even though an absolute discharge was granted to Matt. The gold standard is what I received in my case and all the other cases I've been involved in with the Buyers Club, at least not for the growers, but for the store, is an acquittal or a stay of proceedings, which is the charges being thrown out. Conviction means that the law is constitutional and the law stands. And unfortunately, in the conviction, the judge essentially upheld the law. And I think part of that was based upon, I wouldn't say poor evidence, but there could have been more evidence, more sufficient evidence to prove some of the points of the defense. And I'll read from some of the Crown submissions. Funny enough, the Crown prosecutor seemed to almost like me through this trial. I was just a witness. I didn't say really anything, certainly not when court was in session. And I don't agree at all with most of what Peter Eccles and the Department of Justice says. However, some of the statements in here are fairly clear and I think a fair representation. Some of the statements, and this being one, in particular the Crown, and this is page 10, section 28, the Crown objected to the unsupported medical opinion evidence and hearsay evidence led from these witnesses. And this is there's 6 witnesses, I think, that ended up testifying on behalf of the Vicks. None was tendered as an expert, no foundation for any of the opinion evidence these witnesses offered, and none produced a single medical, legal report, clinical report, or any other documentation to support their evidence. The hearsay or opinion evidence led from these witnesses is not admissible unless under a recognized exception that would allow it. This excludes medical opinion evidence offered by any of these witnesses, as well as hearsay evidence as to the explanations they claim to have been offered regarding various difficulties they experienced with others not before the court. Example, physicians, licensed or unlicensed marijuana producers. So what the Crown is pointing out, and I think not having heard or the judgment isn't out yet, what I think that the judge would agree with is that, well, the testimony presented by the witnesses was very heartfelt and very truthful. It was not supported by any documentation. When people are thinking to either represent a friend who is growing for them or a club, or just in general, if you're dealing with a medical issue, writing a journal about your experiences, documenting your experiences as much as possible, having doctors put in writing why they refuse to do things is very critical. If the doctor or whoever you're saying things about is not able to be there in court, the Crown will just dismiss most of what you say. And unfortunately, the testimony put forward by many of the witnesses was not supported by documentation, and therefore the Crown was quite able to per se brush it off. And in terms of even preparing for court with a club such as this, or if you're a grower who's helping other people, again, documenting who those people are and why they do not have these licenses from Health Canada, and having, like I say, a journal at the very least documenting what you've been doing is really critical if you're going to be trying to help change these laws. You can't be too prepared when you get into court, even if you're not being qualified as an expert. One of the problems that these people ran into was that 5 out of the 6 people that testified actually had licenses from Health Canada. The one who didn't could have if she had really tried to, but she hadn't tried to as hard as she could have, and that was evident in her evidence, unfortunately. And those that had licenses weren't able to really produce evidence of how difficult it was for them. They talked about certain problems, and I don't doubt the judge accepted their testimony, but again, without documentation, it's really hard to build concrete facts upon. And in some cases, I would even suggest that the evidence from the witnesses may have hurt the defense. They were trying to argue lack of access and difficulty with Health Canada. One of the witnesses had a license for 56 grams a day, which may be what he needs, but to argue that it's a problem getting access when you have a license for over 200 plants,